Every day that I am in court, I require $1,400.
You're a real person named Randall Crane. Oh, is he a sovereign citizen? I have very little patience for that. No attorney on this green earth is going to come in and make the frivolous argument. I asked you a question and I'm telling you to answer it. If you don't know your sovereign citizen arguments well enough to come up here and say them, have a seat.
What you're about to watch is one of those courtroom encounters that starts out looking almost harmless and then slowly turns into a complete disaster for the defendant. On paper, this case is incredibly minor, a misdemeanor obstruction charge tied to a traffic stop, plus a few civil infractions. Normally, these hearings take minutes. Most defendants show up, acknowledge the charges, talk to a lawyer, and move the process along. But Randall Crane has something very different in mind.
Here on people of the city of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James Kazicki. I'm the House Counsel. I spoke with Mr. Crane. Had a breakdown in communications. I don't believe I can go forward representing him. We do not support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is. And I explained that the rights that you have.
Well, I understand my rights.
Hold on just a minute, please. Hold on just a minute. I want to make sure I have the complete file. Mr. Kazicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane, you're here for an arraignment. As I explained, sir, arraignment.
And this right here is actually one of the smartest things Judge Chun-Gan does during the first hearing. He refuses to take the bait. Notice how Crane keeps trying to steer the conversation toward jurisdiction, legal theories, and abstract arguments instead of simply answering procedural questions. A lot of sovereign citizen-style defendants rely on creating confusion, forcing endless debates, or getting emotional reactions from the court. But the judge never really gives him that opportunity. Instead, he stays laser-focused on procedure, charges, rights, bond conditions, court dates. That's it. No emotional confrontation. No ego battle. And because of that, the hearing never fully spirals out of control. What also stands out is the attorney withdrawing almost immediately because they do not support the same theory of law. That's courtroom language for, I cannot ethically make the arguments this client wants me to make. Lawyers can't knowingly present arguments with no legal foundation, and that becomes a huge theme later when the second judge explains why no attorney is willing to argue these theories in court.
Is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you? Okay, sir. So in this matter, You are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference. So you're going to meet with an attorney here in the court. You write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m. All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, they can't be sent to jail for these. They're simply not criminal offenses. All right. You'll be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
This section is incredibly important because the judge is doing exactly what courts are supposed to do, making a clean record. He repeatedly explains the purpose of the arraignment in plain English, clarifies the defendant's rights, outlines the charges, and even explains the possible penalties step by step. That matters because later on, defendants sometimes claim they didn't understand the proceedings or weren't informed properly. Judge Chun-Gan is carefully eliminating that possibility in real time. But notice Crane's strategy. Every time the judge tries to move into standard courtroom procedure, Crane pivots toward vague objections or abstract concepts. He says he understands his rights, then immediately suggests he doesn't understand jurisdiction. This creates a strange loop where the hearing can never move forward because the defendant keeps redirecting the conversation away from the actual case.
Well, I'll explain it again. You come back on July 16th in court for a pre-trial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part. But what I don't understand is I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges formally lodged.
Well, I would also like to advise the court that every day that I am in court, I require $1,400, and I will be charging the court $1,400 for my time.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
Here's where the hearing starts drifting into classic sovereign citizen territory. Crane keeps refusing to give clean, direct answers while simultaneously insisting he doesn't understand the court's authority. But legally, misunderstanding or disagreeing with jurisdiction doesn't magically stop a criminal case from existing. Courts don't require personal agreement from defendants to exercise authority over charges filed within their jurisdiction. What's interesting is how carefully the judge separates actual legal rights from the defendant's personal theories. He explains the bond. He explains the next hearing. He explains the civil infractions. And despite Crane repeatedly interrupting with jurisdiction concerns, the judge keeps bringing it back to reality. Your next court date is July 16th.
Sam, I can tell you can't have a court. I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense. While operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial, okay? Those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court-appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question, and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir, here, can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now and read your rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you don't understand them, read them.
I move for this court to dismiss.
Have a seat.
Okay, next case. This is
Judge Shackelford recognizes the playbook almost instantly. The second the attorney mentions constitutional arguments and sovereign-style claims, you can practically feel the courtroom atmosphere tighten. Unlike the first judge, who approached things with extreme patience and restraint, this judge decides immediately that he's not allowing the hearing to become a theatrical debate. And honestly, you can understand why. Courts see these arguments constantly. Claims about being a living man, rejecting corporate identity, denying jurisdiction, or insisting ordinary laws don't apply have been repeatedly rejected nationwide. Judges know these theories go nowhere legally, which is why Shackelford cuts directly to the point instead of entertaining a philosophical discussion. What makes this exchange especially revealing is Crane's confidence level. He genuinely appears to believe he's cornering the court with jurisdiction challenges. But from the judge's perspective, these aren't groundbreaking legal arguments, they're repetitive internet theories that fail every single day in courtrooms across the country. Clip. In the end, this entire hearing became a perfect example of the collision between internet pseudo-law theories and actual courtroom procedure. Randall Crane walked into court apparently believing he could challenge the legitimacy of the entire process through jurisdiction arguments, living man claims, and sovereign citizen rhetoric. But both judges, despite having very different personalities, ultimately handled the situation the same way, by grounding everything back in established law and procedure. If you found this courtroom showdown as wild as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal drama analysis.